alleged in the indictment was that the attempt occurred on Burford. There was an intervening interval. And then later, short period later, but later, there was a completed act on Holmes. Okay, that's the argument that I understand is being presented. And that's why I'm going to look at the merger part of it. Now, how that fits and whether or not it merges, I'm probably going to take a few more moments to think that through and how that works. But that's what I understand we're looking at as far as the legal issues. I understand the kidnapping part of it. You have a kidnapping just because you moved them within the office. We're not going to allege it. Flip side of that is, I mean, you look at some other statutes like the, I don't want to tip at windmills, but when you look at police chases, I mean, you can be charged with obstruction 5 times in the same chase. So, I mean, the issue may seem simple, but it's not. But this is the way I'm going to approach it. Okay.
Thank you, Judge. And I believe the reason for the merger really comes down to the issue of double jeopardy, because you have to put the defendant on notice, because you do not want there to be an opportunity for the state to come back with double jeopardy, which is why you want to get as specific as possible, and which is what we did in order to designate these 2 separate instances in time and in place. So that is the state's argument as far as count 9 merging into count 8. And that is what I have for Mr. Goff. Now, Your Honor, with regard to the legal argument that Ms. Hogue made on behalf of Greg McMichael, actually, Noel was then cited in the case of Jeremy Scott, who killed Dexter Holliday. It was a Fulton County case. Embarrassed to say it was my own. And in that case, we had to resentence Mr. Scott because what the court did was sentenced him on the felony murder conviction, but then actually when he was found guilty of possession of a firearm by a convicted felon, the court went and took the possession of a firearm by a convicted felon, merged it into the felony murder, then merged the felony murder into the felony murder for the armed robbery. And the court went and cited to Noel. And this is Scott versus the state, 302 Georgia 29. It's a 2017 case. The state notes that based on Noel versus the state, the trial court erred in merging the felony murder convictions and then merging the predicate felonies into the remaining murder conviction. When the trial court sentenced Scott on count 2, the felony murder based on aggravated assault, count 3, felony murder based on possession of a firearm by a convicted felon, was vacated by operation of law. Therefore, count 6, possession of a firearm by a convicted felon, then cannot merge into count 3, which stands vacated. We therefore vacate the merger of count 6 into count 3, meaning the possession of firearm by a convicted felon, into the felony murder that it's based on, and remand for resentencing on count 6. Now, factually, you are a convicted felon at the moment you're shooting that person. It happens at the exact same time. So I think that kind of goes towards that, well, if it's all happening at the same time, it needs to merge together. And I will also direct the court to a case I affectionately call the El Camino case. Once again, unfortunately mine. This is DeMarcus Graves. It is Graves versus the state, 298 Georgia 551. Once again, a 2016 case. And at that point in time, basically it said, while the evidence was sufficient to sustain Graves' conviction, we find an error in sentencing. The trial court purported to merge 2 felony murder counts with the malice murder count. The trial court then purported to merge 2 independent felonies, criminal attempt to commit armed robbery and possession of a firearm by a convicted felon, with the 2 murder counts. And basically what they said in Graves was, no, you can't merge the felony murders into murder. You have to vacate them by operation of law. And once they're vacated by operation of law, that's going to leave you with the possession of a firearm by a convicted felon and the criminal attempt to commit armed robbery. Therefore, the trial court is required to vacate that portion of its sentencing order, purporting to merge the 2 independent felonies and impose proper sentences on those counts, which I then had to go ahead and do and resentence Mr. Graves to the murder charge with those 2 particular felonies. So there are 2 cases right there that show that that is not the case, because they murdered Mr. Graves while attempting to rob him of his drugs while he was sitting in his El Camino in the parking lot of an apartment complex while being convicted felons. All of that took place at the exact same time. So therefore, Noel does not stand and has been overruled basically by Scott and Graves. So with regard specifically now to Greg McMichael, the idea that there was no vigilantism here because after they confronted people, after they took their guns to confront people, after they confronted those people with those guns, then they would call the police, is somehow a neighborhood watch situation. As Officer Rash testified, they're supposed to be witnesses. That's what neighborhood watch is there for. They're supposed to be great witnesses. Officer Rash said he thought Greg McMichael would be the best witness, being a prior law enforcement officer, that he'd be able to come in and take the stand and say what he saw. That's what neighborhood watch is supposed to be, not somebody running after people in a residential neighborhood where there are women and children and people out walking on a regular basis. This was a Sunday afternoon. It's a miracle they didn't run into families taking a walk that day. And on a random day, when the GBI went out with the drone videos and were just going through the neighborhood, they captured numerous people out taking a walk. A family with children were there. So the next point, that Greg McMichael has shown no remorse or empathy because he's unable to. Well, Greg McMichael was a law enforcement officer. But what he did on May 5th of 2020 was release evidence in an ongoing investigation into himself and to his son. Greg McMichael's the one who released the video to the media. He went to Mr. Bryan and said, hey, give me your phone. I'm going to take it to my lawyer. Took it to his lawyer and had his lawyer release it publicly because he believed it was going to exonerate him. That's interference with administration of justice. Yes, we did not charge him with obstruction or anything like that. But the fact of the matter is this is someone who was in law enforcement for years and actually actively pursued evidence in a case against him to be released to the media because he believed that that video showed he and his son were not guilty of anything. That's 2 months afterwards. The state's position is he hasn't changed his mind. The state's position is he and his son still believe they didn't do anything wrong. And that is a lack of remorse or empathy. The idea that he did not intend the death of Ahmaud Arbery, once again, he's a law enforcement officer, got a gun, went running after somebody. The jury did find that he intended to commit false imprisonment, criminal attempted false imprisonment, aggravated assault with that pickup truck, and aggravated assault with that shotgun. And we all know that felony murder has a foreseeability component to it. Ahmaud Arbery's death was foreseeable, and especially foreseeable to someone in law enforcement. The idea that they wanted to get to the bottom of what an unknown person was doing in some neighbor's house, a neighbor they didn't even know, goes back to our vigilantism. This whole idea that they were trying to help the neighborhood out has been an excuse from both Travis and Greg McMichael. Ms. Hogue got up here and said, this wasn't advancing the progression of the crime. And I apologize for this once again, Your Honor, but stop or I'll blow your fucking head off. I think that really advances the progression of the crime. You're threatening to murder somebody. You're threatening to kill him if he does not stop. And referring back to the post records produced in the bond hearing, Greg McMichael was so not paying attention to his job as a law enforcement officer that he was not post-certified from January of 2006 through 2014. He was an investigator in the district attorney's office, and he let his post-certification lapse from 2006 to 2014, 8 years. I won't even go into what that could have meant to those cases that were prosecuted by the district attorney's office. He then lost the post-certification again in 2018, and Jackie Johnson had to make an accommodation and change his designation at his job just so he could keep his job through retirement. This attitude of I'm special and I'm above the law and the law doesn't apply to me and I can take my gun and I can run after people and confront the homeless guy under the bridge and then call the police later about it. That's vigilantism, and that is the main reason. The thoughtlessness, the remorselessness, the desire so to be special and protect himself and his family by taking evidence and releasing it publicly when he knows there's an ongoing investigation is the reason we are asking for life without the possibility of parole. And with regard then to Travis McMichael. There's a reason, Your Honor, you did not grant bond to Travis and Greg McMichael. Mr. Rubin went back to all of those things listed in the bond hearing. The state will also direct the court to things the state presented in the bond hearing, including his text messages with all of his offensive racial animus and language. The jury did find that he had an abandoned and malignant heart. That's exactly what the jury found. They were given that he intentionally went ahead and did this, or the other level, abandoned and malignant heart. In addition, I will remind the court that there's an old saying, the road to hell is paved with good intentions. And it's great that they had such good intentions to protect the neighborhood. But the thoughtlessness, the lack of vision to know how this could go terribly, terribly wrong. And the fact of the matter is, Your Honor, it was a year and a half. February 23rd, 2020. November 2021. Travis came in here and testified. The state asked that you take into consideration his demeanor, his attitude. He said, this was the worst day of my life. Well, how'd that work out for Ahmaud Arbery? Not once did he show any empathy or ability to place himself in the position of Mr. Arbery on the stand. And yes, 4 minutes of conduct. Well, 4 minutes of conduct. Usain Bolt won 8 gold medals. When he runs those races, they're less than 2 minutes long. But the reason he's able to do that, the reason he is able to win, is because of 20 years of training that leads him to those 2 minutes. Those 4 minutes are a reflection and a result of an entire lifetime of Travis McMichael and his attitude, his demeanor, what he believes he's entitled to go ahead and go do. The same applies to Greg McMichael. That 4 minutes of conduct wasn't just 4 minutes of conduct. It was a culmination of vigilantism. We get to go ahead and play law enforcement even though we're not, and that we're going to go out and confront people, and we're going to take our guns to go do it without any real understanding or consideration of the consequences. At this time, for Travis McMichael, these are the reasons that we are asking for life without the possibility of parole. Thank you, Your Honor.
All right. That being all argument and evidence presented, and I say that just to be clear on the record, there had been some discussion with counsel about evidence and the record. The court is going to leave the record open, as I understand it, for what's going to amount to a notice of filing and 2 affidavits, just in order to preserve arguments made during the trial on appeal. I'm going to take about 10 minutes, maybe 15 minutes, and go through my notes, and then the court will pronounce sentence. We are in recess for 15 minutes.
Well, there you go. Judge Timothy Walmsley will go and reflect and double-check and do the things any good judge does before imposing sentence, especially such a severe sentence that is possible in this case. Hello, I'm Terry Moran. Judge Walmsley, the judge in the trial on the death of Ahmaud Arbery is going to hand down sentences to the 3 men who have been convicted of the murder of the young black man who was simply out for a run in the wrong neighborhood, it turned out. And what we heard today, are very early on, from Ahmaud Arbery's family asking for justice. They believe the sentence should be the maximum under law, which on conviction of murder in the state of Georgia is life in prison. And the only question that the judge has is, should he allow the possibility possibility of parole for these defendants, for one or any of them, or all of them, or should he just impose the maximum sentence? And their lawyers had a chance to speak, and we heard at the end from the lead prosecutor who described them in terms that she believes are correct, that the evidence bears out that there should be no possibility for parole, excuse me, for these defendants. So for more on this, let's bring back C.K. Hoffler. She's a trial attorney, the former president of the National Bar Association, and former homicide prosecutor Bernardo Villalona. And so, C.K., let me begin with you first, just on your reaction to how the prosecutor summed up the case, for no mercy here, really, from the court under law, for the maximum sentence. And she really drew on the testimony of the defendants themselves, of Travis McMichael in particular, and described it. She described their attitude as one that evinced really no empathy and an arrogance that led to the death of Ahmaud Arbery, and that should result in no possibility of parole. What did you make of her arguments? You're muted. You're muted. You got to unmute.
I'm so sorry about that.
There we go.
I felt that her arguments were very compelling. I felt that her arguments, Terry, reflected the evidence in the case, what the jury heard and what the jury ruled, the verdict of the jury. She also brought in a couple of pieces of evidence that the jury did not hear and did not see. She talked about the text messages, the exchange of text messages, and the racial animus in some of the text messages. That probably will be the subject of the subsequent hate crime case. But I think that she was exceptionally compelling in dismantling the arguments of all three of the defendants in a persuasive way. And I think that the judge, more than likely, is going to find that her arguments were persuasive, because after all, they do reflect, quite frankly, the verdict of the jury.
The verdict of the jury. They found the facts in this case. Thank you, C.K. And Bernardo, in the state of Georgia, as I said, the sentence for murder off the bat is life in prison without the possibility of parole, unless the judge grants it. It's up to the judge to decide that. First, forgive my ignorance here, but is that common, or do other states allow a little bit more leeway given the circumstances of murder? And in this case, do you agree with C.K. that really the prosecution has a strong case for no leniency at all in these life sentences?
So these sentences are quite common. For example, in New York, if you're convicted of murder in the second degree, which would have been probably the charge in this case, you can serve anywhere from 15 to life or 25 years to life. That's the maximum. But if you're convicted of murder in the first degree, then you get sentenced to life without the possibility of parole. There is no discretion when it comes to murder in the first degree. But either way, you have the appropriate sentence and a recommendation, which is life without the possibility of parole, because you have committed the worst crime that you can commit, that there are no do-overs. You cannot bring the life of Ahmaud Arbery back. And that's why the sentence is so high. So while the defense attorneys, yes, they are pleading, oh, they've been good, they've been law-abiding, this is their first contact with the law. Yes, your first contact, and it was a big one. You went from 0 to 100 real quick on February 23rd of 2020. And the sentence that's deserving in this case is the one of life without the possibility of parole, because in the end, Ahmaud Arbery, he won't ever come back.
And his family, thank you, Bernard. His family will never have the opportunity to be with him again. And it is at this stage of the trial of these men, Gregory McMichael, Travis McMichael, the shooter in this case, and Roddy Bryan, that the Arbery family finally gets to step forward in court. And under Georgia law, as is typical in many states, the victim impact, the impact on the family, on the loved ones of the lost in this murder case, got to speak. And we have a little bit of that, I believe, that we could hear from earlier today, just before we hear sentence. The judge will come back in just a few minutes. Let's listen to the family talk about what this case, Wanda Cooper Jones first, who was Ahmaud Arbery's sister and his mother, excuse me, and what she had to say about the impact of this crime on her.
I want to first speak directly to my son, if I please. This verdict doesn't bring you back, but it does help bring closure to this very difficult chapter of my life. I made a promise to you. Today, I laid you to rest. I told you I love you, and someday, somehow, I would get you justice. Son, I love you as much today as I did today that you were born. Raising you was the honor of my life, and I'm very proud of you. Your Honor, these men have chose to lie and attack my son and his surviving family. They each have no remorse and do not deserve any leniency. This wasn't a case of mistaken identity or mistaken fact. They chose to target my son because they didn't want him in their community. They chose to treat him differently than other people who frequently visited their community. And when they couldn't sufficiently scare him or intimidate him, they killed him. My youngest son, he was born on Mother's Day of 1994. He had a smile so bright it lit up a room. He was a greedy baby that seemed like he was always searching for something to stick into his mouth. He was always a loving baby who seemed to never tire of hugs, cuddling, and kisses. He loved, he never hesitated to tell me, his sister Jasmine, and his brother Marcus that he loved us. And, Your Honor, we loved him back. He was messy. He sometimes refused to wear socks or take good care of his good clothing. I wish he would have cut and cleaned his toenails before he went out for that jog that day. I guess he would have if he knew he would be murdered. My family is gonna miss Ahmad. We're going to miss his jokes, his impersonations, his warm smile. These men deserve the maximum sentence for their crimes. Ahmad never said a word to them. He never threatened them. He just wanted to be left alone. They were fully committed to their crimes. Let them be fully committed for the consequences. Your Honor, I'm standing here before you as the mother of Ahmaud Arbery, asking you to please give all three defendants who are responsible for the death of my son the maximum punishment in this court, which I do believe is life behind bars without the possible chance for parole. Thank you.
Wanda Cooper-Jones, Ahmaud Arbery's mother there, the nightmare of every parent to lose a child, but to lose a child in this way is an agony. And that now comes into evidence. And if I could just go back to C.K. Loeffler on the idea of a victim impact statement. It was pretty controversial when it came into American law, but it enriches our law and enables the judge to hear firsthand the evidence that is relevant to punishment of what this crime has done.
Absolutely. And it's really important because the jury didn't get a chance to hear much about Ahmaud Arbery other than the negative stuff that came in through the trial that the defense brought in. And so it's so important to humanize, for people to understand this is the real tragedy. This is the real devastation. This is what it means to murder someone when the mother, the father, and sister give these victim impact statements. It's as real as taking a knife, putting it in their heart, and turning it. His mother could barely breathe. His sister had a similar disposition, and his father just had a look of helplessness and hopelessness the entire time. So yes, while early on these were controversial, they are incredibly helpful, especially, just think about it, it comes in at the sentencing stage of the equation, and the judge gets to hear something that up until that point he probably has never heard.
And if we can, we're waiting for the judge, Timothy Walmsley, who retired, to deliberate and make sure that he understands what he's about to do, which is impose sentence on these men, very serious sentence. But if we can hear just a little bit from Ahmaud Arbery's father, Marcus Arbery, who, as C.K. just said, testified a little bit earlier this morning, so we can hear from his mother and his father on what this crime did to them.
It's a hard time with me and my family. You know something that doesn't sit right with me at this time. The man who killed my son has sat in this courtroom every single day next to his father. I'll never get that chance to sit next to my son ever again. Not at a dinner table, not at a holiday, and not at a wedding. He'll never get to have I pray that no one in this courtroom ever has to do what we did, that buried their child. There's no word for that because no word knows that much pain.
Marcus Arbery there speaking with painful eloquence about what it means to him to have lost his son. And Bernard, if I can go to you on the relevance of this. You've been in a lot of trials. How much does it impact judges, do you think? I've covered trials where victim impacts have come in. I should say it's very different sitting in a courtroom with someone expressing that pain and watching it on television. We're showing it because of its news value. But how much does it affect the judges? Does it vary?
It definitely affects the judge. I tried homicides, or I prosecuted homicides for 10 years. And of course, at the time of sentencing, we would hear different statements from family members. And sometimes it went to a point where they were so shaken and so upset that they will give me the letter and say, can you read this to the judge? I can't do it. It is very painful. It is traumatizing. But what I used to tell the family members, you don't want to regret not having the ability to express yourself to the judge, to let the defendants know how you felt and how you're affected by this. Losing a loved one, it is so hard and difficult to do. I lost my sister in May, and I always think about what were her last moments like. She was by herself. So I think when Dad was talking now, it's unfortunate because he saw what was Ahmaud's last moment, that he suffered, that he was scared, that he was in anguish. And that is the sight, like his father said, he will never forget. So with these victim impact statements is that you want to put the judge in your shoes so the judge can see and feel what you're feeling. So when he hands out the sentence that is supposed to fulfill punishment, deterrence, and rehabilitation, he takes that into account.
Very well said, Bernard. I'm sure feeling it. I'm thinking of my own boy, and can't imagine, what they're going for. But CK, if I could switch to the other side here. We did hear from the defense lawyers today, and their basic, as Bernardo was speaking earlier, their basic argument is these people lived lawful lives. They had not previously had, any significant criminal activity, and those minutes where this went down should not cancel all that out. That was the argument. How is that usually weighed in these cases?
Sometimes it can weigh favorably in terms of the sentencing of the defendant. There's no prior history. However, in a case like this,